Now, Washington Mornings on the Mall. 105.9 FM. And AM 630. WMAL.
7:07, Brian and Brian, you're tuned to WMAL. It's where Washington comes to talk, and sometimes we listen to very smart people talk, like Joe DIGENOVA. Joe, how are you?
Good morning. I'm great.
It's good to have you. Look, high doings at the High Court today as the Supremes begin 3 days of hearings about Obamacare. Pretty unusual to have 3 days of arguments, wouldn't you agree?
This is unprecedented. It's rare for the court to grant multiple days of argument, but I think it's safe to say that a law enacted by Congress by violating its own rules for parliamentary procedures and which transforms 14% of the United States economy into the equivalent of a welfare state is perhaps the single most important case since Dred Scott.
All right, so you think it's worth it. I gather you have an opinion about this particular case.
Well, this is about process for me.
Right.
I think the manner in which the Democrats control both houses of Congress and ram this through in violation of Senate and House rules is one of the most abominable acts of anti-democratic legislation in history. But the Democrats, as they always do, smiled and loved it because they won.
All right, so what's going to happen today? I mean, there's a couple of different things going on here, right? Number one, they're going to take up the case of whether or not, what I think it's called the Anti-Injunction Act, which is, can you even take a case to the Supreme Court if the law itself doesn't take effect until a later time?
Now, this is an interesting twist. The Anti-Injunction Act was passed in 1867 after the Civil War to make sure that taxes would be collected from formerly rebellious states. It says that you cannot challenge a tax until you are forced to pay it, until it's actually imposed. Because the administration argued in the beginning, while this was under so-called legislative process, they said that this penalty was not a tax. After the bill passed and the challenges were filed by the 26 states, the administration said, oops, this is a tax, because they wanted to prevent the litigation from going forward. Being faced with the basically preposterous nature of that argument, they actually changed their position again in the Supreme Court and are now arguing that it is not a tax for purposes of the Anti-Deficiency Act because they think they have the votes to have the law upheld in the Supreme Court.
If it's not a tax, then what is it? Because the IRS is the one that enforces it. It's just
because actually, as described in the legislation, it is called a penalty, literally called a penalty in the legislation, but it is collected through the Internal Revenue Service, which uses tax-style collection techniques to actually collect the tax. The Supreme Court probably will rule that this is not a tax, that the administration cannot have it both ways, and that they're going to reach the substance of the case. If they don't, if they put it off, that means that they would not be allowed to hear the case until 2015, when the first taxes are actually collected in an income tax filed for 2014 in April of 2015.
But why would they go through that whole process of trying to determine whether or not they can indeed hear the case?
Because it is, in fact, a serious question. I may make light of it and say I think they're going to rule this way. But the issue of whether or not this is a tax is actually a very complex question. In fact, it's so complicated that the Supreme Court actually assigned a lawyer to that provision of the case. In other words, there's nobody arguing now that it's a tax. So the Supreme Court hired its own lawyer to argue today that it is in fact a tax. They assigned someone, and he is going to be given time today to argue that everybody should go home today.
Is there anything else that the government does that levies it as a fee versus a tax?
No. The way the law is drafted, again, Congress did a pretty sloppy job. Here's the problem. When you try to slam something through without regular order in the legislative process, you always make mistakes. This is an example of that, coupled with another important issue, which is they forgot to include a severability clause, which means if you strike down one portion, the rest of it stands. They were in such a hurry to ram this through, in violation of the House and Senate rules, that when they repassed the bill that came over from Pelosi, the Senate, Harry Reid, Mr. Brain Trust, the dumbest guy in American history ever to run the U.S. Senate, forgot to put a severability clause in the bill, and that's why the issue is alive today.
All right, and the severability clause suggests that if one portion of the bill is deemed unconstitutional, then the whole thing has to go?
It all falls. Under the severability rules, in order to save it, the Supreme Court would have to go through a Nijinsky, a set of leaps and bounds. Mm-hmm. The reason they put severability clauses in all legislation is to prevent courts from having to reach the issue. Once they say it's severable, the courts are not allowed to address it. They cannot even begin to think about whether or not they forgot to put it in here, and because it's not in there, the court now not only has the right, it has the duty to decide whether or not, let's say the individual mandate falls.
Right.
If that falls, can the rest of the law stand? Then they have to go into an analysis which says, okay, the money from that funds this, this, and this. Well, if you don't get that money, if you strike down the mandate, then there are 9, 10 other provisions in the law that are simply dysfunctional. So then the court has to say, is that really a law when that much of it is gutted by collapsing dominoes of language? And the answer is it has to fall. I mean, there's no way the statute stands without the mandate because the mandate provides the funding.
Court watchers look very carefully at past rulings and precedent and try to get some sense of where particular justices might come down. Do you think, based on what you know about all that the Obama administration can find 5 judges?
Well, I think they certainly can, and they may also find 5 judges on the other side of their argument. This is a legacy case. This is a case for which all the justices will be remembered, and don't you think they're not thinking about it? Especially Anthony Kennedy, who is perhaps among the most political of the justices on the court. And I don't mean political in a partisan sense. I mean a political in his sense of the view history will take of him.
Right.
He is very conscious of that. Anyone who's ever been in private conversation with him can tell you that. But I think that trying to predict this is very, very difficult. Because, again, this is a case that will be like Dred Scott. It will be read by children in grade schools in the future. By the way, for people interested, the most incredible article I have read about this by a fellow named Adam J. White is in the March 26th edition of the Weekly Standard. It's called Without Precedent, and it is the single best piece I have ever seen written about this, and I really commend it to people. But believe me, everybody is going to be watching the questioning by the justices. And even though you can't always tell how a justice is going by the questions that they ask, this is going to be a great one. I can't wait to hear the arguments.
I've been in the Supreme Court, and I've watched arguments take place, and I think you do get a sense of it. I mean, I almost always
You're a better man than I, Brian.
Well, I mean, I'm not 100% on this, but the times that I've gone, I walked away with a definite sense of where the justices were.
Well, I hope you get a chance to hear the arguments and let us know.
Yeah, right.